Hearsay is admissible. Anything's admissible, pretty much. They just open the floodgates. Somebody wants to say something and puts it in writing, that's good. I don't care. No, I'm sorry. I'm going to require strict compliance with the rules of evidence. I want to take you over to the rules of procedure here. We'll go back to that. When you get into that, if there's a legitimate claim against you, right? And they can prove jurisdiction. It is the way it is. Okay. Remember we were talking about those documents in accordance with the strict rules of evidence. This is in the family law. Okay. 101, scope of rules, what they can and can't do. 102, rule number 2, rules of evidence, applicability. Upon notice to the court filed by any party within 30 days after a response or other responsive pleading is filed. So if in the event that you don't do the notice of special appearance objecting to the personal jurisdiction, and you legitimately want to fight this, you believe, especially if you're the moving party, right? And you want to try and go through this, or you're being subjected to this, you still can go back and object to the jurisdiction, but it's gonna be tough. But let's say where you are right now, in the middle of a case, and you want to go back. You're being served with something, whatever. Upon notice to the court filed, you have to file the notice, and it's a demand, right? Actually, this would be a notice that you will require strict compliance with the Idaho rules of evidence. Because if no such notice is filed, all relevant evidence is admissible. What did I just show you there? Only strict admissible evidence. This is backwards. I know it's backwards. I know it's backwards. But here it is. It's telling you. It's telling me here in Idaho. If not, then this admissibility standard shall replace everything. Right? Hearsay is admissible. Anything's admissible, pretty much. They just open the floodgates. Somebody wants to say something and puts it in writing, that's good. I don't care. No, I'm sorry. I'm going to require strict compliance with the rules of evidence. Okay? Further, in fact, pursuant to Idaho Rules of Evidence 514 A, C, and D, alleged statements are confidential and are not to have been disclosed, as well as Idaho Rules of Evidence Rule 801 is hearsay and inadmissible as evidence. Now, pay attention here. 514 and 801. Remember that? 801. What was that under that? Oh, stop. Back to those rules of evidence. I can show you exactly how that is. Oh, wait. Where was that? That was here. And here. Right here. 801 through 806 is the hearsay. And if you don't require strict compliance with the rules of evidence, hearsay is admissible. Right there. Do we get this trickery and how to get out of it? Or not necessarily get out of it, but restrain them from using fraud and fraud upon the court and getting away with it. This gets rid of all that crap. Should be the other way around, but this is the game they play. So, trying to teach you folks how to effectively defend your rights. Now, because of that hearsay, and that this is, I'm claiming that that's false, and I previously said that she's going to have to prove her claims. I said it's false, and here is the truth. And guess what that amounts to? That amounts to Idaho Code Section 185409, punishment for perjury. Perjury is punishment by imprisonment in the state prison not less than 1 or more than 14 years. That's felony. That's prison time. That's a $250,000 crime per instance, per person. So there's one.